Hello, everybody.
Good morning, sir.
Good morning, Your Honor.
Calling case number 24RO08431. This is People of the City of Royal Oak versus Jacob Michael Ellis. That's you, sir?
Yes, Your Honor.
Thank you, Mr. Ellis. Today's the date and time for your informal hearing. An informal hearing is just that. This is not a criminal proceeding. Nobody's going to jail this morning on this traffic ticket, but it is considered serious enough that Officer Hull did issue it on the date in question, which was November the 2nd of this year at about 10:30 in the evening. You were operating a 2024 Integra, black in color, on Washington Avenue at or near 11 Mile Road. At that place and time, you failed to yield from a private drive or alley, and an accident occurred. Officer Hull prepared a Uniform Michigan Traffic Crash Report, UD-10. And so the citation before the court, Mr. Ellis, is failed to yield accident. You may admit responsibility in this matter. You may admit and explain any circumstances you believe are mitigating, or you have every right to deny responsibility. The court will swear the parties and we will take testimony. What would you like the court to do?
Well, I would just like to make a short statement if possible.
You may make a short statement. However, it does have to be in a context. So
Yes.
this court is confined to the requirement of taking a plea. If you do not believe you were responsible for the motor vehicle accident, that is certainly your right and your privilege to assert that, and the court can take testimony under oath. Or if you do believe you are responsible, you are still permitted to provide any explanation or statement you wish.
Thank you. I will just say I'm a longtime resident of the city.
You need to pick one of those doors to walk through. So you can either admit responsibility and explain, or you can deny responsibility and also explain.
I see. I will admit responsibility and plead no contest at this time. I will just say I have a good driving record, almost 15 years without a moving violation. This was a minor incident with very minimal damage and no injuries. I'd like to request a dismissal of this charge and would be willing to plead to a lesser offense and accept a reduced fine if possible, in ability to resolve this matter quickly. And I appreciate your time and consideration. Thank you.
Okay, Mr. Ellis, the court appreciates your statement. The court is not permitted to accept a conditional plea or haggle with you about points. That's not within this court's purview. Believe it or not, the court doesn't have unlimited magical powers. It has fairly specific powers that are ordained, so to speak, by the legislature and then the chief judge of this district. So the court wishes to, again, make it clear to you that the court can't make any promises, but you do wish to admit responsibility. Is that what I understand?
Yes, Your Honor.
Okay. I believe the court gets the gist of this. Officer Hull, what would you like to share?
Yes, Magistrate. Everything that Mr. Ellis said was true. It was a very minor accident. There's very small damage. From what I remember, he does have a good driving record. That being said, I'd love to make a motion to dismiss.
Motion to dismiss. Wow. That's a clean sweep, Mr. Ellis.
Wow.
All right.
Thank you very much.
No worries. Good luck to you. And always drive safely. Always look both ways twice. Take care.
Yes, Your Honor. Thank you, Officer Hull.
Result, I can waive formal reading, stand my client mute for the purposes of the arraignment. I would just ask the court to recall or set aside any warrants in the matter.
Thank you very much. Good morning again, Ms. Urell. You understand what's happening today is called a bench warrant arraignment, right?
Yes, sir.
Okay, and this matter has never been disposed of, although it's had a number of pretrials set. So
Correct.
at this time, the court recalls the bench warrant from lien, and we reaffirm your original plea or pleas of not guilty. Ms. Urell, do you wish court-appointed counsel in the future?
No, sir. No, Your Honor.
Okay, well, here's what the court is going to do, given the fact that you would be working up to your third attorney on this matter since last July. The court is assigning counsel. They will be available to you. They will be assigned through the IDSO office. If at any time you actually do retain your own counsel, they will understand the procedure in terms of how to haul off your court-appointed counsel from IDSO. But at this time, the court is indicating court-appointed counsel shall be noted and approved for now. What's going to happen next, Ms. Urell, is this matter will be set again for a pretrial, and you will receive notice to the address that you reported to this court. That will direct you when and how to appear for your next court date, and your IDSO counsel will be contacting you likely over your telephone before that happens. So in the meantime, the court does have to address itself as to the issue of bond. That's not intended to prejudge or punish you. You have your presumption of innocence on this matter, but the court must set bond in order to ensure that you do reappear and to afford any necessary protection for the public. In that regard, Mr. Mikos, what do you like to share?
Thank you. In regards to bond, I'm hopeful that the court would consider a reasonable bond, even a personal bond in this matter. Obviously, with the bench warrant, there are, concerns about the defendant's appearance. However, after speaking with Ms. Urell, she's indicated to me she attended many of these court dates. I think ultimately she changed her address at one point. And the most recent notice was lost in the mail because of that change. She is anxious to get this matter resolved and put behind her. She works full-time. She's a 9th grade teacher at UPrep High School. And again, she's here on a nonviolent misdemeanor offense. So I do believe a personal bond would be appropriate for those reasons. Thank you.
Thank you very much. Ms. Urell, when setting bond, the court is simply attempting to ensure one's reappearance and to, as well, afford any necessary protection to the public. In that regard, looking at a CCH in this matter, as well as other issues, the court is most concerned about a series of pretrials in this matter that were adjourned specifically at the request of the defendant, and then ultimately failures to appear as well interstitially therein. The court does not believe she qualifies for a personal bond. The court has extreme concerns that she is not going to appear. And Ms. Urell, if you change your address, you're under a standing order by this court, as it is a rule across the board that you are to notify the court of any change of address, telephone, or email. And this court has not moved one brick since 2001 on this corner. And before that, it was on across the street since 1953. The court doesn't move, but apparently you do. The court has had a great deal of difficulty in trying to afford you your presumption of innocence and give you your fair forum in order that you might be able to conduct this matter as you wish, either in some form of a amicable disposition or your right to a trial. But if you don't come to court, that can't happen. Ms. Urell, these following conditions will apply to your release. You will appear as directed for all your future dates. You will abide any valid order or judgment entered in this case. You're not to leave the state of Michigan without permission of the court. Please don't commit any crimes while you're on release status. Please do notify the court in writing of any change of address, telephone, or email. You will be making reports to pretrial services. No alcohol, marijuana, or any other controlled substance without a valid prescription from a treating physician. You will participate in initial substance abuse and alcohol screening. You will not purchase or possess a firearm or other deadly weapon. You will not enter any business premises in Royal Oak or Berkeley, except for work, court, or medical reasons. There will be an initial drug screen. And if that's negative, Ms. Urell, you'll get every benefit of the doubt, and there will be no further tests for controlled substances. If it's positive, you'll be tested 3 times a month. Similarly, with respect to alcohol, there'll be an initial ETG test. That is a test which will do in essence, a 96-hour look back for the consumption of alcohol. And if that's negative, will need be no further tests. And if it's positive, you'll be tested 1 time a week. Also, no release without a GPS tether. And at the time of the last failure to appear, Judge Meineke had set bond in the amount of $5,000, cash surety 10%. This court will see fit to reduce that amount to $2,500, cash surety 10%. And again, no release without a GPS tether. That way, there won't be any more difficulties in getting you to your court dates and getting you matched with the counsel that you wish to assist you on this matter. And with that, Mr. Mikos, is there anything further?
Nothing further from the defense, no, sir.
Thank you. Ms. Urell, you can get up. Good luck to you.
I love you all so much. Be safe, be well, sleep sweet, and much love.